Good afternoon and welcome back to the Maryland Public Service Commission. When we last left off, we were taking a look at some of the regs regarding termination of service for master metered properties. And pursuant to a notice we issued on August 21st of 2018, which was 2 weeks ago today, we notified the public that we would be continuing our review of the proposed regulations that we marked up on the 21st. At this point, hopefully all the parties, including those parties who argue they did not receive sufficient notice, have had an opportunity to review those comments, speak with their colleagues and other interested parties, and put us in a position where we can move forth today on the proposed regulations. With that, I recognize the party at the table.
Okay. Thank you, Your Honor. Fran Francis on behalf of the Apartment and Office Building Association. I personally wasn't here at the last hearing, although AOBA was represented by counsel, who might not have been as sensitive to a couple of these issues since he didn't participate in the actual settlement discussions. I was a participant in all settlement discussions, and while AOBA did not sign the settlement agreement, we did agree to it and state that we had no issues with it. I do want to state our concern, and it is with the language that was added at the last hearing, and that is on section, I think it's this new section I, where it says each utility shall identify and maintain on its records those accounts for service to master metered buildings to ensure that service is not terminated prior to compliance with the provision. That is not a sentence that I have difficulty with. I do not have difficulty with the last sentence that says the utility shall ask the customer at the time a new service application is submitted whether it's a master metered apartment. My concern is around the second sentence that was added at the last hearing. And that sentence is, it shall be the responsibility of the customer to inform the utility that service is being provided to a master metered apartment building. I do have concerns there. I am only really familiar with Washington Gas and PEPCO and their rate schedules and how they maintain data. I know for Washington Gas, they do know their master metered apartment buildings because there's a separate rate schedule for master metered apartments. So my concerns really address how PEPCO plans to handle this, and it revolves around creating any kind of new database and procedures that would add significant costs to the master metered apartment class in the middle of a rate case when we're allocating cost to customers who do pay their bills and who haven't had any problems. So that's my concern with how do you get the customers to report? What kind of processes? What kind of database? How are you going to create that? Who is going to maintain that? From what I understand, anybody that they know is a master metered apartment, they do code it that way. But I know that AOBA has probably somewhere, I don't have the numbers with me, probably around 100,000 apartment units in membership, and that's just in Prince George's County and Montgomery County. And we certainly don't represent all of the apartments in those jurisdictions. I wish we did, but we don't. I am concerned about the record keeping and the costs that will be added to that class or that group of customers when that one sentence is added.
Ms. Francis, is your concern solely related to the jurisdiction of PEPCO?
It's solely related to the jurisdiction of PEPCO because Washington Gas already has the data. They have a whole separate master metered apartment class, so they must know who's a master metered apartment. They receive bills on that rate schedule.
As I recall, it didn't appear that there would be any extensive additional costs associated with this, but perhaps Mr. Seegers from PEPCO could shed any additional light on how PEPCO accounts for possible ratepayers that they may not know are master metered customers.
Good afternoon, Mr. Chairman, Commissioners. Matt Seegers appearing on behalf of both Pepco and Delaware Power. Speaking for both companies, in terms of record keeping, the company already maintains a list of the master meter facilities that we know of. So as we learn of additional facilities, we would simply add them to that list. So we don't believe that there will be any significant cost burden associated with that. In terms of notification to customers that they need to notify us that they are a master meter facility, the companies have not yet determined how that will be accomplished, but cost is certainly something that we will take into account when we make that determination. It could be done through a bill insert. It could be done through a postcard. So we would certainly look for the least expensive way of doing so, but we don't anticipate that there will be a significant cost burden with doing so.
Thank you. Good afternoon.
Good afternoon, Mr. Chairman, members of the Commission. Damon Krieger on behalf of BGE. And since it was BGE that introduced the language the last time upon which the Commission voted to accept, I figured I would say a few thoughts on the matter. And I'm not familiar with WGL's rate schedule, but obviously it's a rate schedule, so I'm assuming that the customers elect to participate in that particular rate schedule, so they notify the utility, and at which point they become a master meter customer. That's in effect what we're asking here, is the customer has to notify the utility so that we can appropriately code the utility as a master meter account. I'm speaking for BGE. We already have a characteristic in our IT system, so we would just indicate as such that it is a master meter account, and then that would give us the information that we need to properly comply with all the notification requirements. So in terms of any incremental costs, at least the way the regulation is written right now, it's the website. We already have a website, so it's just adding language to our website, and consumer pamphlet, which is something we already have in place, so it's just adding a little bit more verbiage in our consumer pamphlet. So whether or not we would do an additional bill insert to provide further information to customers to put them on notice, and I think that's something we would consider, and I would think that, you know, hopefully the Commission would support providing that additional information to customers to the extent a bill insert would provide an opportunity to do so, but I don't see any significant incremental costs. We already have the systems in place.
Thank you, Mr. Krieger. Ms. Francis, anything further to add?
No, Your Honor. My only concern really is one of costs. And, you know, knowing my members, one postcard doesn't always get to the right person who even knows whether the building is a master meter department. Many people use bill-paying services or third parties. So I am just concerned anytime I hear the company saying that it's going to create a new database or a new billing system or a new additional customer education pamphlets. I do know that adds costs, and the costs are my only concern with that sentence.
Thank you. Does the Commission have any questions for these parties? No. Is there any other party that wishes to speak? Mr. Aker.
Mr. Chairman and Commissioners, Mikhail Raker on behalf of the Office of People's Counsel. Just a quick note, based on a list provided by staff, we were able to circulate all the notices and were able to schedule a call between interested parties, and that took place last Thursday. So just a quick update to the Commission about the status of notification and stakeholder involvement. And one just additional point of concern, I know I spoke about this last time, we continue to have a bit of concern with Part I as drafted and with the new language. And we still continue to think it creates a bit of ambiguity about, for instance, what the utility would do if it was notified of a master metered building but not through the customer directly. And we would propose to add an additional sentence after that first sentence, something along the lines of the utility shall update its records if it has reason to believe that service is provided to a master metered building. And we think that would clarify instances of community organizations or other organizations notifying the utility that maybe a building is master metered, of a occupant calling the utility and saying that this is a master metered building. We think that just adds a little bit more clarity between that first sentence that says that the utility shall maintain on its records the list and that second sentence that says that it shall be the burden of the customer.
How does Mr. Ricker, how as you propose this, how does an occupant have a relationship to modify someone else's, a customer records with the utility? I don't understand that.
Well, the customer wouldn't, or the occupant rather, wouldn't have the ability necessarily on their own to modify that, but they would alert the utility that that might be a possibility. Whereas otherwise, the utility might not know of the existence of that.
I guess I was getting hung up on
relationship.
the utility shall update their records. I think that's what you said.
If it has reason to believe that service is provided to a master meter building.
So an occupant calls, now they have reason to believe, and it shall update their record. I'm stumbling on that proposal here a little bit.
Is there any comment from?
Well, if I might, Commissioner, I actually have to say I think staff would agree with that. It's problematic to have somebody other than the customer provide the utility with information upon which the utility is then expected to act with respect to a third party's account. I mean, I find it difficult to contemplate, say, a community organization informing PEPCO that they think this building might be a metered building, and PEPCO acting upon that information without having gotten verification from the customer, because ultimately it is the customer that's the only person there who can really verify the status of the building.
Can I just ask staff, at the last hearing, it was my understanding, if I heard the companies correctly, it is their current practice when they become aware, if they're in the field and they are aware that the building is a master metered, or if they are about to terminate service, if they're aware at that point it's master metered, then that they treat it at that point as a master meter, even if it hadn't been coded up to that point. Is that correct? And maybe maybe the utilities could just confirm if I heard that correctly, because I had a lot more comfort with this once I heard that the practice was not going to change.
And that's my understanding as well, Commissioner. And in that instance, clearly the utility has objective, verifiable information that this building has a master meter on it, and it's therefore it has to be a master metered account. And so that's a much more concrete form of the utility finding out that the building is in fact master metered. That works. There's no problem with that.
Did OPC, did you hear the same thing that I think I heard? It sounds like I did in fact hear that the current practice is to do pretty much what you're suggesting, in that when they're in the field, or if they become aware that a building may be master metered, that it is coded at that point. And I see nodding, so I guess that's...
We did hear that, and our only concern was to make sure that that's enshrined in the regulations, rather than simply noting that that's a practice of the utilities at the current date, and a practice of maybe all the utilities here, but maybe not some other utilities that aren't here to join us today.
And I would argue that the first sentence of each utility shall identify and maintain puts that burden squarely on the utilities to maintain their database. I am concerned, similar to Commissioner O'Donnell, with the language that the utility should update its records if it has reason to believe. The reason to believe language here is uncomfortable for me. Ms. Francis, did you have a comment?
Yes, I do. Even with these new regulations where we defined occupant, we defined one as who has a legal right to reside in the building. PEPCO will not know unless they hear from the customer whether any such occupant has a legal right to live in the building. There may be many occupants in a building that, of course, perhaps shouldn't be there. And they also don't have a list of the occupants, obviously. Some do, many don't. But I think we need to be careful when we expand the duties beyond the customer of record that PEPCO maintains.
Thank you. Mr. Raker, anything further from People's Counsel?
No, that was our only recommendation. I could amend that to say that the records would be updated once confirmed with the customer, if that alleviates any concerns. But the only kind of main issue we would pose is that, at least from our perspective, Mr. Chairman, there would be a bit of ambiguity between that first sentence as initially proposed and the revisions. So I think with that, I have no other comments, but thank you.
I have a question related to a different subject. Mr. Raker, in your proposal, you wanted to add to 8B in 310308B, at the very end, Office of Home Energy Programs, which administers the Maryland Home Energy Assistance Program, right? And so I guess I'm not really certain why you wanted to add that, because it seems like a lot of, bunch of extra words, and we all know they do that, and it's not that the notice is going to tell people that they administer it. It's just, so I'm kind of confused as to why we needed that.
I appreciate that, Commissioner, and that email and the additional sort of, I would call them minor, non-material edits came as a result of the call with the called stakeholder group, and I think that particular edit originated from maybe Chop Tank. I'm not sure if anyone from Chop Tank is here today, but their thought was that would help clarify that particular provision. So I don't at this point say that OPC is in support of that amendment, but that was a compilation of what came out of the stakeholder call.
Okay,
and
thank you.
discussion. So thank you for that.
Mr. Raker, can I ask you, when you did outreach, and I appreciate the outreach to beyond the settling parties, did you include PE?
We did, Commissioner.
They of course, objected at the last meeting for that lack of notice, so I appreciate that.
I'm not sure if anyone from PE is here, but on the call it sounded like they were okay with the revisions as the Commission proposed.
Good afternoon, Mr. Chairman, Commissioners. Robin Leone here on behalf of Potomac Edison Company. Mr. Raker is correct. The Potomac Edison Company is supportive of the rules as revised. I think the only issue at this point that's sort of open for us is just timelines on some of the things that the companies would have to implement. That's something that's not been set in stone yet. So some of the things like setting up a system internally or a database, that kind of thing. But otherwise, we are supportive. Thank you.
Mr. McDougall.
Thank you, Mr. Chairman. SMECO has a question of clarification. And this is in the definitional section of master metered building. I believe it is COMAR 20.31.01.02 B13. SMECO is not at the hearing last time, but I did have the opportunity to listen to the hearing a couple of days later. And it was my impression that the Commission would include in this definition common areas of a large building with or a building with 4 or more dwelling units in it. Here's my scenario, and maybe this will clarify why I'd like clarification. We have got a couple of customers that have I call it retirement homes, and each apartment is separately metered, and the customer of record is the person who lives in that particular dwelling unit. The owner of the entire facility has another building, or part of the same building, with common areas. Where residents meet, where they play games, where they do other things that residents of those buildings do. That is a separate account. It's a commercial account, and it's in the landlord's name. I wanted to make sure that we were handling this right, and that the common areas, let's say that landlord doesn't pay its bill, and we were to issue a notice of termination to that landlord, not for the individually metered apartments where the residents live, but for the main building. Even though that is a commercial account, I gathered from the commission's hearing that that would be considered a master metered building. And I'm here seeking clarification because I wasn't quite sure by the end of my listening to the 3 hours of the hearing.
So you're asking if let's say this is a recreation room?
Sure. Let's say it's, a retirement home, we'll say. You walk into the main building, there's the offices, there's an area where residents congregate and do recreational activities. There might be meeting rooms in there. But then off of that main facility, there are rooms, there are apartments where people live. And each one of those apartments is separately metered. The person living in that apartment is SMECO's customer of record. Of course, if that customer did not pay his or her bill, we would issue notices we normally would with any residential account. My question is, if the landlord, the owner of the building, does not pay its bill and we are to terminate service to the non-living areas, the common areas, the offices, the places where they congregate and do recreational things, is that part of the master metered requirements that we need to comply with? That's
Just so I can understand your scenario.
I'm sorry.
All right. Okay. No one lives though in these areas you're talking
They
about.
do not.
And if the landlord does not pay, you will still be providing service to those individually metered.
That would be correct. Now, if let's say the landlord did not pay and we terminated service to the landlord's account, the person living in the apartments, they would walk down the stairs and the lights would not be on in the common area where they come down to walk out the front door because the service has been terminated. And this is a commercial. But and they can go back to their room and get all their air conditioning, their the lights and everything else that are that people do when they live in an apartment. I'm just talking about the common area associated with this, these sorts of situations.
So, Mr. McDougall, I think the answer, to me, it's a legal question that would depend on the circumstances and how people pay for their apartments and that sort of thing. That would be to be interpreted by the lawyers of the facility or SMECO. I'm not sure that the commission could. I don't know, but it seems like it's difficult to opine on this, not knowing all the circumstances of what the leases say and so on and so forth.
I totally understand your point, Commissioner Herman. In fact, when I was looking at the definition of master meter building, common areas did not seem to me to be defined in there. I couldn't find that sort of situation that I was opining on. But I was trying to. I didn't go back and listen to more of that hearing than just once, and so I was a little confused.
You raise an interesting fact.
So I was looking for some commission guidance if you happen to have any at this time. If not, I'll be happy to interpret it as I move forward. And if a problem ever arises, which I certainly hope it would never do, we can make that decision based upon that fact situation at that time.
I personally would be hard-pressed to find that to be a master metered building because each of the dwelling units have an individual meter. And I imagine you would only have one meter for the commercial areas.
That would be correct.
Would, Mr. McDougall, would those commercial areas be under a different tariff and not Schedule R, right?
It would be under a separate tariff. It would be under one of our commercial tariffs. Yes, sir.
Okay.
Well, I think I've got the answer to my question. It's a fact situation that would be specific to whatever circumstances arise in the future, and hopefully this question will never come before the commission again.
But you will cross that bridge when you get to it. Any other parties wishing to speak on the activities of the past 2 weeks or the proposed regulations? Seeing none, do commissioners have any additional comments regarding the proposed regulations? If not, appears that we are prepared to vote on these proposed regulations. Is there a motion?
Would you like me to go ahead and read the entire motion? Is that how we'd like to proceed?
Is that our typical process? Okay.
Vote. Mr. Chairman, I move that we move to publish in the Maryland Register for notice and comment the revisions to COMAR 20.31.01.02b, 13 and 14, and COMAR 20.31.03.06, filed by the Maryland Office of People's Counsel, Potomac Electric Power Company, Delmarva Power and Light Company, and the Washington Gas Light Company on May 23, 2018, as amended at the rulemaking held August 21, 2018, and here today in this rulemaking, subject to non-substantive changes necessary to conform to COMAR drafting requirements.
Thank you. Is there a second?
Second?
All in favor?
Aye.
Any opposed? The motion passes. Is there any other business before the commission today? Seeing none, this hearing is adjourned.